All right. Good afternoon, everybody. We will call to order this November 11th, 2021 meeting of the Colorado Oil and Gas Conservation Commission. On our agenda today, we have a revisit of docket 2011-00261, the enforcement matter regarding KP Kaufman. Before that, Ms. Larson, may we get a roll call?
Certainly, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett. Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present today.
Thank you, Ms. Larson. And that is enough for us to commence this meeting with a quorum, and we will do so. This meeting is being recorded. I will ask that at this time that since we're going to be entering into the docket for the KPK enforcement matter, that we elevate the attorneys for staff and for KP Kaufman at this time. All right, I see Mr. Jacobs and Ms. Stafford. I also see Mr. Mueller. Will Ms. Rosenberg be joining us as well? There she is. Okay, I think that is everyone. All the appropriate counsel has been elevated, and so what we'll do at this time is I'm going to ask, well, I guess a housekeeping matter that I'll let Jeff explain about his role as hearing officer in this process. I will be chairing today for this particular matter, but I will turn it over to I guess in this instance, hearings officer Robbins to explain a little bit about his role and then walk us into the proposed compliance plan that we're here to receive presentation on today.
Thank you, Chair Gonzalez. This is Hearing Officer Robbins for the record. I said that because that's just kind of fun to say since I've not been hearing officer before. I am hearing officer because on September 21st, this board voted to direct me to be hearing officer and go work with the parties on the potential for a agreed upon compliance plan that would attach as part of the order of enforcement that this commission will be considering today. I will not serve as a voting member of the commission today. Instead, I will continue in the vein of hearings officer. My non-voting is because the work that I did as hearing officer included individual work with each sides at times that was consented to by the parties. And so I received information sort of above and beyond what commissioners would be privy to. And that was all in an effort to assist the parties to getting to where we are today, which is to present to you a compliance plan that has been agreed to by all sides. So I want to set the stage on what you're going to hear today. Again, on September 21st, this board, including myself as chair at that time, concluded the enforcement and pattern of violation on this enforcement matter. We assessed a $2.1 million and change penalty. And then this commission, as I indicated, directed me with comments from commissioners that you provided to me to attempt to create a global compliance plan that was agreed upon by all parties. I want to note for the record that we did this, but this hearing officer approach, because I think the commission, as well as staff and KPK, all agreed that it would be difficult, if not impossible, to try to figure out the terms of a very complex compliance agreement that involved the adjudicated violation actions as well as a number of unadjudicated violation actions. It would have been very difficult, if not impossible, to do that on the record with all 5 commissioners. And so I think that it was appropriate turn of events to use the hearing officer process. And so that's where we are today. I do note for the record that the commissioners, me included, desired that this matter be before us, not today, but about a month and a half ago. It's taken a great deal of additional time and effort to get to where we are today, which is the presentation of this agreed upon compliance plan. I also want to note to the commissioners that the compliance plan draft was initiated by me. I took the information and the comments that I received and that I indicated as well in terms of what should be part of a compliance plan for all of KPK's matters. And I drafted the document and I had assistance from Hearings Manager Larson and AAG Fugate, but that the basis of the document was a document that I and the AAG and Ms. Larson put together based upon input from commissioners. We then delivered that to both sides. We then held multiple meetings with both sides in which we received red lines to my initial document from both sides. I sought to receive areas in which there was consensus. We started with, kind of here, and then over the course of the weeks and with the multiple meetings, we did get to a spot that as of about, in the last day or so, we do have consensus from the parties, both staff and KPK, to the document that I'm going to introduce to you now. I want to speak a little bit about the matter that's before you, commissioners. I'm going to introduce the enforcement order and the compliance plan that we have reached. It is my recommendation that it be adopted. I also will call upon KPK and staff to provide their perspective on it ever so briefly. I do not need them to go through the details. I'm going to go through the details of the document. And then I want to inform the commissioners, and I'm going to ask AAG Fugate to follow up on me here. What are the options before you at this point in time? And obviously, you can agree to accept the plan and vote to approve it as part of the enforcement order. You can request modifications or amendments to the plan. If you were to do that, you would need to provide opportunity for both staff and KPK to determine whether they are in agreement with any modifications. As you'll hear from me as I go through the document, this was a highly negotiated plan that's before you. And I'm going to speak to some of the negotiations and some of the gives on both sides. So I just point that out. And then obviously the third option that's available for the commission is to not agree to the plan and instead go back to just the normal enforcement order process. If the commission were to do that, and again, I'm going to have AJ Fugate back me up on this, but some elements of the plan would not be part of an enforcement order. In particular, the GRIP, or the Global Remediation Plan, that involves the non-adjudicated NOAVs, as well as all the 901A orders and the action items that are associated with all that. That in particular would be stripped from this document. And so we would move away from what I think is a creative approach of utilization of a professional commission, which is we've utilized the fact that we've got professional commissioners that I could spend time as a hearings officer, and that we could try to provide a path forward for KPK that staff's in agreement that is outside the normal NOAV approach. But again, that is certainly available to commissioners as the third, I think, option for us in terms of action items. I would like to, if it's okay, Chair, call upon AAG Fugate just to sort of make sure I got the options available for commissioners, and if he has anything else to weigh in before I go through the plan itself.
Thank you, Mr. Robbins. AAG Fugate, do you have anything to add?
Thank you, Mr. Chair. No, I think Hearing Officer Robbins gave a good summary of kind of the process that we have in play here. as he indicated, it is creative, but it has provided with a compliance plan that is global in nature, that it does take into account or attempts to take into account some of the locations and sites that were not part of the adjudicated NOAVs that the commission heard earlier this year. I guess I'd leave it to you, Mr. Chair, if you want me to kind of go through in detail what I guess an involuntary order process might look like, or if in my opinion, that might be best to go or have that discussion after Hearing Officer Robbins reviews some of the details of this agreed plan.
Thank you, Mr. Fugate. I think that would be appropriate. Perhaps once we get into deliberations and discussions, if the conversation goes that way and we need more information, I think we'll look to you to provide that. With that, Mr. Chair, or excuse me, Chair, Hearings Officer Robbins, would you like to continue on with walking us through the compliance plan agreement?
Sounds good. Thank you, Chair. So if you all have your plan before you, I'm just going to sequentially walk through the pages. I'm going to skip over the stuff that I don't think is contentious or is more sort of lawyerly recitals, et cetera. And that is indeed the first page, jurisdiction and definitions, and then allegations and findings of violations. That's just reciting what we've already found. And then over on page 5, paragraph 4, there is a paragraph that is the commission's noting that there was an inability of pay information from the record, and that is recognized within this plan in that paragraph. And later, paragraph 5 is a recitation about the work that I was authorized to do as hearing officer. And then sort of the meat of this is, well, paragraph 6 is a recitation of what may occur today. We'll obviously need to alter that depending upon what the commission's findings are. Moving to Roman numeral 4, compliance requirements. Want to note that the first paragraph there, payment and suspension of penalty amount. Basically, this codifies what we heard from the record that KPK, so we assessed a 2.0 million and change fine. KPK provided evidence and testimony that they had an ability to pay of $795 over the course of 5 years. This is a codification of that point. You will note that I drafted this in a manner that would have the 5 years of payments with a non-payment in year 1. The issue around that is KPK desired to be able to use the monies that would otherwise be the payment to help fund the corrective actions up front that are called for by the plan. Staff agreed to that. I, as hearing officer, thought that that made sense. So there would be 4 years of payments with 2 semi-annual balloon payments in the 5th year, equating to the $795, which is the professed ability to pay on part of KPK. Again, this whole document is a balance of noting the fine of 2.0 million and change, noting the desire to enforce payment of penalty, but noting what I heard from all 5 of us as commissioners, that we really wanted to see compliance. And we wanted to see compliance not only with the 7 adjudicated NOAVs, but the 11 noticed NOAVs that have not been adjudicated, and we wanted to see compliance with the other alleged areas of non-compliance that are contained within the 901A order, and perhaps others, all of which are reflected on the Exhibit A. So that's sort of the theme of this, is that compliance with the adjudicated and the unadjudicated, providing KPK a path forward to achieve compliance over the term of this compliance agreement. That was a central theme to the document that's before you. The next paragraph on page 7, paragraph 2, contractors performing the work under this plan. I can state for the record that this paragraph deserved a lot of attention, and there was a lot of tension between the parties about this paragraph, and the process on behalf of staff wanting KPK's consultant to be doing all the work, including the technical work. KPK wanting an ability to have relief from having the consultant do all the technical work. And the draft that you see here, which establishes that for the first year, KPK will do the technical work through its consultant. It will oversee some non-technical work. And then after 1 year, which is sort of KPK proving that to its consultant, to staff, to us as commissioners, that it has the capacity to do some of that, that there could be a relaxation of the standard. That would only occur after a year. It would be to the discretion of the commission. It would be at a hearing at commission, and it would be after full information from staff, from the consultant, and from KPK, along with consideration in the Roman or subparagraph D, Romanettes 1 through 3, also whether KPK has had any new spills or releases. So that's the balance that was achieved in terms of the contractor. I do believe that it meets the goal of staff, ensuring we've got third-party oversight of technical work and doing the technical work, oversight of non-technical work, at least through the initial stages, with the opportunity for KPK to relax that requirement if this commission believes that's appropriate later on down the road. That generally sums up paragraph 2. Paragraph 3 is the dedicated project account. This is what I would call escrow account light. We are ensuring that KPK is funding each month up to $150,000. That number is staff's guess as to what each month's work may equate to. We are not requiring a escrow account heavy, which is going to a third party, making that third party review and approve of all distributions and all of that. I did not think that was necessary. Staff agreed, and we think this sufficiently establishes oversight on the part of the commission and staff, while establishing some flexibility without not being overly onerous in terms of what an escrow account should look like. There is a monthly reporting obligation in paragraph C, and there is a final accounting in paragraph D. Okay, paragraphs 4, 5, 6, and 7 deal with the 4 remaining projects or adjudicated NOAVs in which there are outstanding obligations on the part of KPK. I'm not going to go into these in particular detail. I can say a few things globally as to all of them. I took the staff wish list basically with regard to what needed to happen in terms of corrective actions for each of these 4 areas, and I inserted it into the document. And we did not really, there was not much negotiation on that. This is the list that we received from the environmental manager, as well as John Axelson, who has been very involved in this negotiation. And so for the 4 that have remaining obligations, this is staff's desire. This is what they wanted, including the timeframes and the actual action items. I now want to speak a little bit to the fact that you see for the first time here, this plan speaks to the remaining penalty of, let's see here, it's 1.2 million, 1219530, whatever that number is. That is, if you subtract the 2 million minus the 795 ability to pay, that's the remaining lump sum that we are suspending. And what I did was I've created a number of different action items that, if they are completed successfully, will allow that portion of the suspended 1.2 million to be vacated. So it will not need to be paid. And let me walk you through how I got to that. So we have the 4 NOAVs in which there are action items that need to happen. And we also have the other parts of this compliance plan. We have the global remediation plan, and that was the most important component in my mind, and I think in staff's mind, to this document. And so we took the 1.2 million and we assigned the value to the GRIP of a value of 400,000. We assigned a value to the flow line plan, the spill and release plan, and the comprehensive waste management plan of 200,000 each. So if they are successful in undertaking the obligations of each of those items, the suspended amount associated with that item would be vacated. So they would no longer need to pay it. So that's the carrot and stick approach to this global compliance plan. So if you add up the values that are associated with the GRIP, the flow line, the spill release, and the comprehensive waste, that's $1 million. If you take the remaining sums that are outstanding, the $219,530, and you divide that by 4, since there are 4 adjudicated violations that have corrective actions, you end up with the suspended potential vacated penalty of $54,882.50. So that's how you're seeing a somewhat odd number of $54,882.50 here associated with these 4 NOAVs and the corrective actions. So again, if KPK is successful, to staff and to our determinations that they have completed the corrective actions associated with each of the NOAVs, then the allocated $54,882.50 would be suspended and would no longer be payable. Similarly, if they're successful with the GRIP, they will receive a value of $400,000 that would be vacated. And if they're successful with the spill release, flow line, and comprehensive management plans, each of those would be $200,000. So that is a summary of the suspension of the penalty, the action items that need to be accomplished to solidify the suspension penalty, and contrarily, if KPK is not successful on any of those items, then the associated penalty would become due and they would need to pay it. So that's how we arrived at this in these numbers, and that gets me through my this document. I'm now over on page 16, the Global Remediation Implementation Plan for ongoing and unresolved projects. So this is part and parcel to the plan. This is very important. This is probably the most important part of the plan that uses the creativity of our commission and staff and KPK to establish a go-forward plan for KPK that if they're successful, they can show that they can return to compliance for not only the adjudicated 7 NOAVs, but also the 11 NOAVs that have issued but not been adjudicated yet, as well as the matters associated with the 901A order, and there may be another few in there. They're all on attachment A. And so what this document does is it allows, the first few paragraphs allows KPK the opportunity with a firm deadline to, in association with its primary contractor, submit to COGC staff and the commission chair, that is me, a global remediation implementation plan for review and comment. Staff has an opportunity to review and comment, and we are hopeful that we've created a process that will establish an ability for staff to approve the global remediation implementation plan. It is associated with all the outstanding areas of concern on attachment A. I believe this is creativity within the plan. It allows KPK the opportunity to return to compliance. This is outside the scope of what we would do if we were just associated with the NOAVs, in which case if you pivot to just doing an enforcement order without agreement, you would not have the opportunity to have this. I can say that the terms of this global remediation implementation plan worthy subject of a great deal of negotiation. And I'll sort of leave it at that. The GRIP must include the items on page 17, subset paragraph D, Romanettes 1 through 4. Over on the next page, there is a paragraph that addresses the potential that we've already noted with some of the NOAVs, that some of the matters that KPK has may involve historic potential contamination. And so we've addressed that through a process to come to the commission with regard to that. Paragraph G is remedies. If KPK fails to timely complete, then staff may terminate the tolling agreement and issue the NOAVs, and staff reserves all other rights and remedies. Let me speak a little bit to the tolling agreement and the forbearance agreement. We're going to find that a little later, but you don't need to turn to it because I can just talk to you about it because it's associated with the GRIP. So we have, or staff has 11 NOAVs that have been issued. Staff also has identified a number of other areas in which they allege there are violations, but they've not issued an NOAV. As this commissioner is very familiar, staff has 1 year from the date of discovery, paraphrasing, to issue an NOAV when they find a problem. What this document does is it is itself a tolling agreement between staff and KPK as to all of the areas in which there is not a NOAV issued. That allows staff and KPK to move forward working, and KPK working to come into compliance, and staff's not blowing a statute of limitation because they've told the deadline for the statute of limitations. The other component of this is this document is also a forbearance agreement between staff and KPK. And what that means in non-lawyer terms is staff agrees to not further prosecute the 11 issued NOAVs for those sites. Now getting back to the remedy stage, if KPK is out of compliance with the GRIP, staff has the ability to terminate the tolling agreement, stop the forbearance agreement as to the issued NOAVs, issue new NOAVs, and move forward. Basically, it would be the same thing that staff would be doing if you determine that you do not want to have a compliance agreement and you just want to have an enforcement order. Staff would have the opportunity to move forward with that. Correspondingly, KPK would have the opportunity to appeal to the commission the 901A order. So everyone is agreeing to sort of stall out rights that exist, and instead, getting back to the theme that I started this with, utilize the path that we've created to allow KPK the opportunity to come into compliance. Over on page 19, paragraph H, that is the $400,000 value associated with the GRIP. If they timely complete it, then it can be vacated. If they don't, then it can become due. The next paragraph is the flow line system integrity plan. There was a lot of negotiation around the terms of this document, but this document is very important to this overall compliance plan. The matters, so it's basically, it's a two-step flow line. First, there is the flow line system integrity evaluation. That is in paragraph A. And the items in Romanettes 1 through 5 are the areas in which KPK will establish the flow line integrity evaluation. Staff has the opportunity to review that, paragraph C, and assuming it is approved, and if there's non-approval, there's dissension, all parties agreed that they would bring it back to me as commission chair, as hearing officer person, to try to work through any disagreements. You'll find that throughout this document, that we tried to establish an informal opportunity for internal disagreement in that manner. The Paragraph D establishes that the integrity evaluation, the first step, will provide the basis for the second step, which is the flow line system integrity plan. There are deadlines there. And then in Romanets on page 21 and 22, Romanets 1 through 8, there was a lot of negotiation around what is going to go into the integrity plan. I can say, just as an example, Roman numeral 2, the last clause there, that the integrity plan will recognize that none, some, or all of the flow lines in the field may be subject to a replacement recommendation. That language involved several days of negotiation. And I'll just leave it at that. I can't emphasize enough the amount of time and effort that went into this. I also would note that Romanets 1 through 8, for instance, 4, map that identifies the specific locations of flow lines that are not previously been mapped. 5, an accurate flow line monitoring plan. 6, a plan concerning collision avoidance and line crossing by third parties. 7, a plan that proactively identifies these facts and circumstances more likely to contribute to potential flow line failures, releases, and loss of integrity. Those 4 or 5 elements go above and beyond our current flow line requirements. And that's important to note, that we've received consensus that from staff's perspective, this is very important. This is very important given the concerns staff has with regard to the flow lines and KPK's volitional agreement to do these things. That is all, in my mind, very important. Over on paragraph 22, I'm sorry, page 22, there is the paragraph E in which staff and the commission chair needs to approve the plan. And then there, if any disagreements, I would put my hearing officer hat on. And then the $200,000 penalty associated with the flow line plan. The comprehensive waste management plan is set forth on page 23. This is something, again, like the flow line plan, like the global remediation plan, this is something the commissioners called for in their deliberations on September 21st. We got agreement on this fairly quickly compared to the flow line and the global remediation plan. There is a value of $200,000 attributed to that. The spill release report and training plan. This too was something that the commissioners asked for, and we were able to negotiate. Feel pretty good about where we ended up with regard to that. Would then turn to paragraph 12, page 24, monthly compliance reporting. The commissioners, certain commissioners desired to have a monthly compliance reporting. Staff and KPK, sort of early on in the negotiation process, agreed to the language that is within paragraph 12 and 13. There became a recognition on everyone's part that our COGCC system is already a vehicle that can be utilized to establish monthly compliance reporting. And so this language is based upon that. Quarterly reports to the commission in paragraph 13, page 25. As I mentioned earlier, in Roman numeral 5 on page 25, in paragraph 1, this is the language about staff's agreement to forbear during the term of this plan, enforcement or any additional initiation of enforcement as to the 11 NOAVs that are issued. And then paragraph 2 is the tolling agreement for the other alleged violations where there's not an NOAV. So we toll the statute of limitations so it does not have to be entered within 1 year of the date of discovery by staff. I want to speak to page 26, paragraph 6. This is the commission review of compliance plan and 901A order. Basically, this is negotiated language between KPK and staff relevant to the 901A order. From staff's perspective, staff was very much wanting to see compliance, corrective actions on the 901A order areas before KPK would have been allowed to seek authority to allow some of the shut-in wells to be not shut in. KPK, on the other hand, desired that some of the shut-in wells be allowed to return to production. One, they are of the opinion that that creates unintended consequences with regard to the lines in terms of flow and et cetera. And two, the funds from returning to production are necessary and important to being able to undertake the corrective actions. What we have negotiated is the language contained within this document. It was the subject of intense negotiations, but both sides agreed to it. Basically, KPK will agree not to seek relief from the shut-in orders for approximately 7 months. This gives KPK the opportunity to prove to staff that it actually is going to, speak to what it's doing. It's going to prove up that it can do these things. And then in May of 2022, KPK can come to commission and seek relaxation of that order, and we would review KPK's compliance. And so that's where we ended up with the 901A order. I would point out, so starting on page 26, Roman numeral 7, terms and conditions. A lot of this is lawyer stuff or boilerplate language that the parties have agreed to. I would note that this is a 5-year term, paragraph 4, page 27. I would note that there are remedies set forth at the bottom of page 27. And then I do want to go into a little detail on page 28, paragraph 6 and 7. The direction we received from some commissioners was that there should be no transfers away from KPK during the pendency of this plan. Some commissioners were okay with transfers into KPK. KPK was not in agreement to that. Staff wanted a chance to review. The language we have here establishes that, and the other thing is that we can't bind KPK from a business perspective from doing transfers. They have that authority outside of our rules and regulations. What this establishes is that no such transfer will be approved by commission absent a commission hearing, which is a higher bar than just allowing the director to approve it. So I think I started out by saying that this document is substantially consistent with the direction of commissioners. This is one of the areas in which some of the commissioners desired to see a little bit more. I believe that staff negotiated in good faith to get as good of a deal as we could on this. I am in agreement with that as well. Another direction that we received from certain commissioners was that they desired to see KPK be required to bond up during the pendency of this. We did not get an agreement on KPK to do that. They have professed throughout that they have an ability to pay, an ability to pay for corrective actions to a certain extent. Bonding up just removes that money from that perspective. I tend to agree with that. So this is another area in which we didn't get complete direction from commissioners, but we do have the fact that KPK is going to work cooperatively with staff in reviewing KPK's financial assurances to see this plan. I believe that is my summary of the terms of this 29-page document. I would like to have an opportunity for staff and KPK, would perhaps start with KPK, Chair, if that's okay, and give them an opportunity to speak to this ever so briefly. I do not think we need to go through what I just did, but just sort of provide the commissioners your perspective about this compliance plan, and then have the same from staff.
Thank you for that presentation, Hearings Officer Robbins. And I guess this time, if counsel for KPK would like to add anything or additional commentary to what Hearings Officer Robbins just said, we'd like to hear that. And then we'd like to hear from staff following that as well. So I'll look to you, Ms. Stafford, when KPK is done. So for KPK, are we hearing from Mr. Mueller or Mr. Jacobs?
Thank you, Chairman Gonzalez. You're hearing from me.
Go ahead, Mr. Jacobs.
Good afternoon. I want to thank Hearing Officer Robbins for that summary and for all of his effort in working as a hearing officer in mediation sessions with our team and with staff and their counsel. I truly appreciate the dedication he's shown to trying to get an agreement. And we're pleased to be in front of you with an agreement which our chairman and CEO has put his signature on. So I hope you'll take that into account in your deliberations. Turning to just very briefly the high spots of KPK's impression of the agreement, we've had significant concerns throughout these negotiations. We've been able to address them in a number of different ways, not entirely to our satisfaction, but well enough to get agreement, which is usually the case in a difficult, hard negotiation and compromise. We think it important that we have several express opportunities to appeal disputes to the chair or to the commission. We in particular, because of the concern about historic contamination and not being held responsible or de facto responsible for that contamination by having to plan for and conduct remediation even when evidence shows that it's not KPK's contamination. We appreciate resort to the Rule 526 procedure that's outlined in the plan as drafted and agreed to, and that's very important to KPK. We further appreciate the ability to amend the plan if necessary, including Attachment A. We have some concerns about some of the Attachment A locations. We weren't able to agree to remove any of them. We think those will be candidates for early consideration of amendment or perhaps Rule 526 determinations that would pull them off that list. So the procedures in here give us enough flexibility to live with the obligations. We appreciate very much the suspended penalty, the payment schedule as proposed by KPK, agreed to by staff, and endorsed by the hearing officer. We think that is essential to our being able to front end load our corrective action and plan and contractor engagement efforts to comply with this plan and implement its measures fully. So with that, I will stop talking and let Ms. Stafford speak to staff's concerns. Thank you, Mr. Chair.
Thank you, Mr. Jacobs. Ms. Stafford, will we be hearing from you?
Yes, Chair Gonzalez, you will be hearing from me. Thank you.
Please go ahead.
Again, good afternoon. I'm Caitlin Stafford, Assistant Attorney General on behalf of COGCC staff. I would also like to thank Chair Robbins serving in his hearing officer capacity, as well as Mr. Fugate and Ms. Larson for working with us through this endeavor. And I also appreciate working with KPK's counsel on this. Just to give you some brief remarks on the compliance plan you have before you. You know, this is the result of a process that was initiated just over 6 weeks ago following your findings that KPK committed 22 separate violations and engaged in a pattern of violations of the Commission's rules. And as part of that relief that staff requested in this matter, we asked that a penalty be imposed and that KPK be ordered to complete any outstanding corrective actions in return to overall compliance with the Commission's rules. The compliance plan you have before you, staff feels represents a detailed and agreed upon action plan for KPK to achieve compliance, not only by addressing outstanding issues at the NOAV locations adjudicated as part of the enforcement matter, but for all open KPK spill and remediation projects. And those are the projects that are included on Attachment A and that were very important to staff as part of this plan discussion process. As Hearing Officer Robbins walked you through the plan, I don't believe I need to touch upon any sort of specifics there. Just that we do appreciate that KPK was able to achieve agreement with us with respect to the global remediation implementation plan, as we feel that those steps are necessary to ensure that KPK can make further efforts to address all open spill and remediation projects. Staff has maintained here, and following lengthy discussions, we feel we've achieved a tough but fair plan that will serve as the baseline for KPK's renewed focus on compliance with the Commission's rules. Notably, as I believe you all reviewed the plan by now, it reserves the Commission's right to respond forcefully should KPK fail to meet requirements contained within. As staff has maintained since the hearing on this matter first commenced in August, it is of the utmost importance to staff that KPK timely, adequately, and competently address its spills and releases and associated remediation projects. And under this comprehensive plan, KPK will have its opportunity to do just that. Instead of relying solely on our normal NOAV enforcement processes and those associated requirements, both staff and KPK have been able to reach agreement on this comprehensive plan. And ultimately, this plan provides KPK with its opportunity, the opportunity KPK requested from you all during the pattern of violation portion of this hearing, to restore staff's confidence in its ability to both comply with the Commission's rules and live up to its obligations to the state of Colorado. So staff believes this plan will provide the COGCC with assurance that KPK intends to meet its obligations to operate in a manner protective of public health, safety, welfare, the environment, and wildlife resources. And based on the fact that we have achieved a signature from Director Murphy on this plan, along with KPK's CEO, we would ask that you approve this compliance plan as part of your order in this matter. Thank you.
Thank you, Ms. Stafford. I think at this time it's appropriate for commissioners to ask questions of both Hearings Officer Robbins, as well as Staff Counsel and KPK Counsel. So, kind of given that, I've got one comment and one question that I'll kick it off with. First comment is I appreciate the hard work that went into this. This is a thorough compliance plan. It addresses a lot of the matters that I believe we as commissioners were concerned about and had outlined and signposted during our deliberations. And so I appreciate all the efforts from the operator, KPK, from staff, and from Hearings Officer Robbins in putting this together. I think it's a very good document, and I appreciate the level of detail that's gone into it. And so kind of it's going to roll into one of the, I guess, one of my concerns, if you will, and it'll be I'll allow it, I guess, to get more information on it, and I'll pose it in the form of a question, after, I guess, a long question. But I'm reading through this, and this is a compliance plan. It sets out specific compliance requirements for the specific 7 NOAVs that we have adjudicated here. It creates a plan for the outstanding unadjudicated NOAVs that we had not considered. And then, and with those, there's a specific amount of suspension and vacation of the fees associated with those. And then we get into kind of these more global, I will say behavior change plans, if you will, for the operator, for KPK, and these commitments in the GRIP, the Global Remediation Plan, the Flow Line Plan, the Spill Reporting Plan, and the Waste Management Plan. And for each of those, when we add up the amounts of fees that will be vacated from those plans, it's about $1 million, or it is $1 million, is what they total up to. And when I read this, I think the plans are good. I think that they outline specific commitments from KPK, and they set an expectation for what we believe is the appropriate operation from KPK going forward. The one issue I have, and the one question I have, is it seems to me that these plans and the associated penalty vacation associated with these plans occurs at the submittal of the plan. And I'm wondering, is there anything beyond the commitment from KPK that is enforceable under these plans. And I guess my concern is that the plans outline a commitment, and in exchange for that commitment, there is a vacation of the penalty fees. But the commitment's one thing, and performance on the commitment is another thing. And I'm curious as to how that performance on the commitments under those plans will be enforced. Hearings Officer Robbins, I'll let you take that since you've kind of been ringleading this, and then I'll look to counsel from both sides.
Yeah, thank you for that. I am looking back. So the way that I'm just looking, for instance, at the flow line system integrity evaluation and plan, it is, should KPK fail to timely complete the requirements, or should they timely complete the requirements on 9A through D, the commission will vacate. And 9A through D is the entirety of the plan. And this is a 5-year document where it's considered for 5 years. So I'm not of the opinion that there is a premature release of the associated dollars, because they have to create the flow line plan and then they have to act under it during the pendency of this plan. And I think the same thing is with regard to the waste management and the spill release, et cetera. And happy to have staff and or KPK articulate their thoughts about that as well, but that is a good question. But that's my reading of this.
Okay, so is it my understanding, your reading of it, Chair Robbins, that the suspended penalty will not be vacated until after the completion of those plans? And so it wouldn't be at the 2022 stage gate, it would be more at an associated 2027 stage gate that those fees would then be vacated?
It could, in my opinion, it could be at the conclusion of this plan. I believe KPK has an ability under this plan to say that for instance, the waste management piece has been done and it doesn't have to wait until 5 years. And if staff's in agreement and we bring it back to the commission, then they could do that. I think there is enough of an ability for each of the plans for, sort of the default is at the end of this term, but for certain of the things, it could be earlier. And I'm not sure if that's going to happen or not, but I think that the plan does have that ability of discretion, and ultimately it comes back to commission as to whether to release the funds.
Thank you for that, Hearings Officer Robbins. Do councils have anything to add to that? Ms. Stafford?
Chair Gonzalez, thank you. I believe that's staff's understanding as well of this plan that Hearing Officer Robbins just articulated. I would also point you to Section H of the GRIP, where we call out upon timely completion of all the corrective actions set forth in the GRIP, the commission will vacate a portion of the penalty amount. So our understanding of your concerns lines up with Hearing Officer Robbins.
Thank you, Ms. Stafford. That's helpful. Mr. Jacobs, anything else? You're on mute, Mr. Jacobs.
Thank you, Mr. Chairman. I do generally agree with Hearing Officer Robbins and Ms. Stafford. I would just point out that on one end of the spectrum is the language in that subparagraph H that Ms. Stafford quoted you regarding all corrective actions being completed under the GRIP. On the other end of the spectrum, for possible earlier vacation of suspended penalties, would be in my view, the waste management plan and the spill release reporting training, which can be completed more quickly than all of the attachment A locations that are subject to the requirements of the GRIP. So I see it as a gradation, a spectrum of time in which suspended penalties might be vacated, only upon commission approval, of course.
That's very helpful. All three of y'all, thank you very much. That was a gap in my understanding in reading this even a couple of times. So so long as we're all clear on that, I'm going to give it some more thought as I kind of read through it, and I will look to my fellow commissioners for their questions. I see Commissioner Nanjapa with her hand up. Commissioner Nanjapa, please go ahead.
Thank you, Mr. Chair, and thank you, Hearings Officer Robbins and AAG Stafford and Counsel for your comments so far. And I just want to echo what Commissioner Gonzalez said with respect to the effort that went into this, and appreciate the thought and considerations that went into it. I have a few different questions and a couple of concerns as well. So one is, and without revealing any of the confidential information that was discussed in our executive session with respect to inability to pay, that the $795,000 amount that is noted there was based on $60 a barrel and was a per year amount, because at the time we were talking about the penalties for the 7 matters that we were adjudicating at the time. So I was curious as to why that 795 was, understanding that there's a need to perhaps focus resources in the beginning towards the compliance that we're trying to achieve and all the cleanup, et cetera. I was curious why that was spread over 5 years. I didn't have anything in my notes that we indicated that as a desired outcome. I think at one point we even commented that the 2.1 million, the full amount, could be spread out over a number of years, but I did not think that was the case for the 795. And I was wondering if there could be some comments, and I have some additional questions as well.
Hearing Officer Robbins.
Well, I think I'm going to allow Attorney Jacobs to also comment. I'll comment ever so briefly that during discussions, we did hear from KPK that the monetary penalty approach was consistent with ability to pay, in particular when you combine that with ability to fund all of the corrective actions and other actions that are being required of this plan. And I approached it from the perspective, because I think I heard from all commissioners that while imposition of penalty was important, creation of global compliance plan for a go forward for everyone with an ability to fund that was the most important aspect of this. Noting that we still did want a significant penalty assessment. So that was the balancing act that I was approaching it. I'm going to stop there, and Chair Gonzalez, you may want to call upon Mr. Jacobs to elaborate on part of his plan.
Thank you, Mr. Robbins, and I will do that. I think so long as a question is not directed to anyone in particular, I will look to you, Hearings Officer Robbins, first, and then to other counsel to answer that. It's kind of wonky the way this is set up, so I want to make sure that we give the opportunity to get our questions answered. So with that, Mr. Jacobs, I'll look to you.
Thank you, Chairman Gonzalez. I'm going to defer to Mr. Mueller, who handled the testimony of our forensic accountant, the unrefuted testimony on ability to pay at the hearing.
Mr. Mueller, go ahead.
Thank you. Commissioners, just to refresh our memories, we did in fact sponsor a witness who put into the record a report he had prepared studying the finances and financial condition of KPK and came out with a recommendation that they could pay $795,000 spread over 5 years. That was the testimony of the economist and accountant, Greg Wise. He based it on his informed estimate of what the price of oil was going to be doing during this calendar year. He used a price that was $75 a barrel. The price is predicted to range up and down this year. In past years, it's ranged from $38 a barrel to $57 a barrel. So it's anybody's guess what it's going to do. We're not wide of that mark as we sit here today. So it's an estimate. Anytime you're trying to guess what a commodity is going to do, it's an estimate. But it's an informed estimate. He testified and prepared a report supporting how he landed on that number. I think it has integrity, and I think it does reflect the fact that this is a cash business, and you can only afford as much remediation as you have money to pay for.
Thanks, Kirk.
Ms.
Thank
Stafford,
you.
anything to add?
And
or
I'll just,
Commissioner?
I appreciate that response. It doesn't match with my notes. And I don't know if I just took poor notes and maybe I need to go back and review the specific testimony. But I think, you know, obviously we're at a higher price per barrel of oil now. And I appreciate, you know, all the considerations and the intent of putting as many resources as possible into achieving the compliance again. I do have a concern, and this kind of relates to what Chairman Gonzalez raised, that the way this plan is set up, although there is the account that KPK will own and deposit money into, COGCC does not receive any sort of deposit in good faith, for lack of a better word. And you could agree to all of these matters in the compliance plan. And in a worst case scenario, you could walk away and we could have nothing, no compliance, no funds. And so that is my greatest concern. And I wondered if either Hearings Officer Robbins or KPK Counsel could comment on that.
Chair.
Go ahead, Ms. Robbins.
Thank you. No, I appreciate that concern. I'll let Mr. Jacobs speak to that point. You know, I would note that if we go down the enforcement order path, we wouldn't have an ability for escrow account at all, or to, you know, establish them to set something aside anyway. And so, you know, we do have limitations with regard to what we were able to negotiate, what we're able to obtain. I feel like this was a solid foundation. And to get back to your first question, Commissioner Nanjapa, you know, I would also sort of frame it that we're not just assessing $795, we're assessing the full 2.1 million. And it's assessed over a term of 5 years. And if they don't comply, the full 2.1 million will be assessed. But they have an ability to trim that by doing things under this compliance plan that I think all commissioners and staff agreed are for the betterment of Colorado, for the betterment of protection, for the betterment of cleanup. So I still come back to, you know, the penalties being assessed, we're just leveraging it in a manner that is protective to the state of Colorado and provides KPK with an opportunity to establish a good, you know, return to good operatorship within the state, which I think is positive. So I'll let Mr. Jacobs speak as well to the initial question that I've now answered another question.
If I may, Mr. Chairman.
Go ahead.
Yes, thank you for your question, Commissioner Nanjapa. A couple of thoughts very briefly. First of all, while I appreciate you raising the concern about an operator in this circumstance under a plan like this simply walking away, I think it's really not a risk in the least. The company has a huge investment in its infrastructure and its proven and unproved reserves in future operations to sequester carbon in the Spindle Field. They're not going anywhere. They've been around for 38 years. Kevin Kaufman's a pillar of the community and a philanthropist. This is not a flight risk kind of situation. I'd commend you to the expert report of Mr. Greg Weiss, our expert forensic accountant, which is, I believe, quite clear that whether it's a lump sum or spread over 5 years, the limit of the company's ability to pay, in addition to the obligations to EPA and the CDPHE under a separate consent decree, is $795,000. I'll also remind all the commissioners that Mr. Weiss, as Kirk alluded to, tried to put a figure of future price of oil into his report. And frankly, it's all over the map. And so he took the spot price at the time of the writing of his report. And that was the best he could do. And he's very experienced in this sort of forensic accounting opinion and ability to pay analysis. So I believe that he did that in a very acceptable manner. And that should give you some confidence as well.
Commissioner Nanjapa, follow up?
Thank you. Thank you, Mr. Chair, and thank you, Mr. Jacobs. Appreciate that additional information. And I, of course, am extremely hopeful that, we can move through this compliance plan and continue through and vacate more of the penalty amounts, et cetera. But, we'll just go back to some of the things that we said in deliberations, that I think there is a little bit of concern, some trust that's been broken, that is, I'm just wanting to kind of look at what we can do to further protect ourselves. And so the next question I have is perhaps for AAG Stafford. What do we know what our total financial assurance that we have in hand for the particular locations or well assets, recognizing that some of the matters, especially that we adjudicated, are not well sites or facilities? What is our total amount that we have that pertain to the matters within this compliance plan?
Ms. Stafford.
Thank you, Commissioner Nanjapa. I don't have that number at my fingertips right now. I know that it is available on COGCC if you were to review the company records. And I couldn't tell you at this particular point which, I guess, how each piece of financial assurance lines up to each particular project or location. I'm not sure that that is something that we currently keep track of in that manner. So I can commit to getting you additional information on that, and I hope that is helpful.
Thank you. I'm sorry.
Sorry, I just received an update. It looks like, just based on a very brief review from what we can tell on the website from COGCC, that it looks like there is about 1.5 million in total financial assurance.
That pertain to these particular locations, or that would?
I think that KPK is carrying overall.
Okay. Okay. And just to make sure I'm understanding, I mean, I know that there are, blanket bonds, et cetera, that we have, but if particular locations that are involved in these NOAVs, et cetera, in this compliance plan, if there was a worst case scenario, how much of that 1.5 million, do we know how much of that would be applicable?
I'm not sure that I can adequately speak to that right now.
Okay. Fair enough.
I would have to look into it more. I'm sorry.
No, fair enough. I would like to understand that better. And as that relates to on page 28, number 7, with respect to the review of financial assurance, one thought I have is a relatively small modification to the language, rather than, let me just pull it up in here. Rather than the commission desires that COGCC staff review the financial assurance, can we actually change that language? I'll look to either AAG Fugate or perhaps Hearings Officer Robbins. Could we change that language to direct COGCC staff to review the financial assurance and ensure it's appropriate, and set a deadline by which that would occur?
Mr. Chair, I'm not sure if you want me to respond.
Mr. Fugate, please.
I was going to say, and I don't mean to kind of punt on that question later on, but I was going to kind of address options that the commission has to modify or make suggestions to modify some of the terms of this after the commission's finished answering questions of the parties, just because there may be some other points where there may be some requests to change the language in minor ways that we may be able to resolve today. So if I could, Mr. Chair, just at the conclusion of commissioner questions, I can give a kind of a fuller discussion of commission options as it relates to what they can do with this plan today.
I wonder, Mr. Fugate, if it might not be beneficial, since I imagine other commissioners may have suggestions in this kind of limited scope, if we could talk about what making amendments may look like, without going into our whole suite of options, since this is one that came up and it may better direct questions and conversation. Is that appropriate? You comfortable with
Absolutely. That? Yep, absolutely. Yep. I'll kind of give my advice as far as what the commission can do this afternoon with modifying the terms of this. As I think all of the parties have stated in their statements this afternoon, this was a precisely negotiated agreement. It's most comparable to the commission's consideration of AOCs in enforcement processes, where because there's an agreement of the parties, any changes or suggested changes of the commission essentially need to be approved by the parties. It would be a modification of an agreement. I'm not saying that cannot happen today, depending on the nature of the changes or suggested modifications. If the parties do have time to consider and agree with those changes, I think we could modify the plan accordingly. If there are some more significant or substantive suggested changes, that may be a more difficult process to go through. Again, it's my opinion that the parties would have to agree to any change to this plan for it to continue for it to proceed as an agreed compliance plan. So I think there are probably some limited ability to modify some of the terms without potentially reopening further negotiation on this plan, which could lead to delay of approval of this plan.
I think that's fair, Mr. Fugate. And if there are, suggestions, minor or substantive is a matter of, I imagine, some subjectivity to the parties. But perhaps they are things that respective councils for the parties may consider as commissioners are discussing their thoughts throughout this process. So I'll kind of just leave it there as kind of a soft, we don't have to decide on it just now. Let's hear from the rest of the commissioners and further from Commissioner Nanjapa if she's got additional questions. Do you have additional questions, Commissioner Nanjapa?
Thank you, Chair Gonzalez. I do, but there's somewhat in that vein of thinking about possible minor modifications. So I will hold for now and let my fellow commissioners ask other questions.
Looking to other commissioners. Commissioner McGowan.
Thank you, Mr. Chair, and Commissioner Nanjapa, thank you for your questions. I have some similar kinds of thoughts or questions similar to yours, and I'll echo what the other commissioners have said. I know that going through negotiations can be really hard, and I'm sure that everybody gave a little and got a little, and I'm very appreciative of all the time that was spent putting this document together. So I'm going to go back to the GRIP because I'm not sure I understand what exactly is in the GRIP and how we came up with the amount that we think the GRIP, I'm going to use put quotations, is worth. So if I'm understanding, the GRIP contains the 11 NOAVs that are pending that did not come to the commission and it had not been settled with staff. We've not discussed those or looked at those. And some, or if not all of the issues that are in the 901A order with the director. Is that correct? Am I understanding what's in the GRIP?
Could I make just a brief clarification? I think we might need it here.
Yes, I'll acknowledge that that Hearings Officer Robbins was nodding in response to your question, Commissioner McGowan. Ms. Stafford, please add the additional color you see necessary.
Sure. With respect to the GRIP, the projects that are included as part of the GRIP are on attachment A, and those include all open spills and remediations that are currently within the commission's database. Those could include locations that are part of the 11 unadjudicated NOAVs. Those could also include locations that are part of the 901A order. But this is a broad and comprehensive list of all open KPK spills and remediation projects as of yesterday.
Okay, thank you. So I'm trying to think of a way to say this that isn't going to just upset the apple cart, but I feel like what we're saying here is that we have put into the GRIP items that may have resulted in significant violations and or penalties that as a commission, if we sign off onto this agreement, we are foregoing in exchange for compliance and remediation and cleanup and things that need to get done with all these outstanding issues in our system with this operator. And I guess if I'm also understanding this presentation and what we're reading, I guess, how do we know that that would have amounted to $400,000, which we are foregoing in another penalty phase if everything is met in the GRIP? And I don't know if I'm explaining my question appropriately. And if it needs more clarification, let me know. Seems to me that it could be whatever it is that we have said, okay, we want this compliance, we're gonna forego going through these additional NOAVs right now and looking at these outstanding violations in exchange for the greater good, which is getting everyone into compliance. Those things could end up being worth more than $400,000. So if the GRIP is not met, the tolling ends and we would re-review those outstanding NOAVs. I don't know how the $400,000 is involved here with the GRIP right now.
Hearings Officer Robbins, do you want to tackle that?
Yeah, thank you. I think, let me try to answer that in a couple different ways, Commissioner McGowan. First, as I indicated in my opening, we took the 2 million, subtracted out 795, found that we had 1.2 million left. We've got a number of different plans that suspend X number of dollars, and I put numbers to it in accordance with what I felt like Commissioner said was most important. So the 400K is the largest number because I heard commissioners, I know I as commissioner desired the most important element of this was something that we're not going to get through enforcement orders if we just go down enforcement order thing, because that's just penalties. But instead it was, let's get a global compliance plan. Let's establish an opportunity through this document to identify all spills and releases and come up with a plan of working on them to get them into compliance. So that's answer number one. Answer number two is, I don't know that you need to worry about whether if you go down the enforcement path, you end up with 400,000 or 800,000, because you're not giving anything up by entering into this global compliance plan. Because if they fail to comply, then the NOAV route will exist and the staff will just pivot to doing the NOAV route. If they comply, it doesn't matter what you might have gotten through an NOAV route and a penalty, because you don't need the NOV route and the penalty. Instead, we've gotten compliance, which is the ultimate end game of what we're trying to accomplish. So I appreciate the creativity of staff, KPK, this commission, in telling us from the beginning, compliance in all of these locations, including the unadjudicated ones, which KPK didn't have to agree to, is really the end game. I think we've developed a pathway forward. If we're successful, bravo. If we're not successful, staff will just pivot back to the path that it is tolling right now, that is not giving up.
Thank you, Mr. Chair. So I think from this commissioner's viewpoint, I understand all of these arguments, but I do see also a benefit to KPK in that they will not be having to pay any violations for any penalties for potential violations, and that is a benefit to them. And instead, they would have had to correct those anyway, even if we went down the penalty route. They would have had to make those corrections, remediations anyway, in addition to a penalty that might have been paid. And so I'm just pointing out that I think that there is a benefit to the operator for us signing off on this. And I will leave it at that. It's my opinion. No one has to agree with me, so I'm just putting that out there. In relation to the financial assurance piece which
Madam
was a
Commissioner,
yes.
if I might, Mr. Chair.
Go ahead, Mr. Jacobs.
Might I briefly respond to the concern raised by Commissioner McGowan? Because, and I want to thank Hearing Officer Robbins for his response to your question as well. But I think this also maybe speaks a little bit to Commissioner Nanjapa's financial assurance concern as well. By agreeing to do all the things we're doing, some of which, as Hearing Officer Robbins indicated, go well above and beyond your flow line integrity requirements now. We'll be doing more than any other operator in the state with a plan that has never been implemented before. And we've decoupled by this agreement the suspended penalty from the 7 NOAVs to which they are attached by law. But by agreement, we can do that. We can decouple them. And we give you $400,000 of suspended penalty. Call it financial assurance on the grip. It's a hammer. And bad things happen to my client if we don't comply. So I do think that while we benefit in terms of being able to get into compliance and doing it in a way that is complementary and recognizes our ability to pay, it avoids a much worse outcome of a business failure, a penalty we can't pay, orphaned well locations, all the things that we spoke to at hearing. So as in any compromise, there is benefit to both sides, and I recognize your concern about benefit to KPK, but KPK has agreed to do a lot more than it has to in exchange for forbearance and other puts and takes in the agreement. And I'll leave it at that. Thank you, Mr. Chair.
Thank you, Mr. Jacobs. Commissioner McGowan, you have the floor.
Thank you, Mr. Chair. So going over to financial assurance, which was a concern of mine during deliberations, I guess I'm finding the terms in this current agreement rather vague and without any, to Commissioner Njapa's point, there's no deadline. It's to review the financial assurance. I'm not even sure that there's going to be anything that comes out of the review of financial assurance. I think the fact that we're at this point, to me, shows that there's some concern about the risk of this operator and their ability to take care of all of their assets, and especially if something goes sideways. And so I'm wondering if RAG could explain to me, under our current financial assurance rules, if we weren't looking at this compliance agreement, what I could request as a commissioner under our current rules to look at financial assurance and increasing it based on either a pattern of violations, the financial condition of the operator, et cetera, and whether or not those would be options under our current financial assurance rules.
AG Fugate.
Thank you, Mr. Chair. And Commissioner McGowan, I do not have a precise answer for you as to if a pattern of violations is something that can trigger an increase in a financial assurance. I can attempt to do some quick research into that, but I do not believe that that is one of the triggers for a financial assurance increase review. Specific to this provision, it essentially leaves it as kind of up to staff discretion on conducting the review and determining if an increase is warranted. So it does simply loop it back into existing process for the financial assurance aspect.
Thank you. So I guess I'd be curious to understand what our current rules allow in relation to reviewing financial assurance. I tried to read my options here, and it doesn't seem like we have very many. The language in number 7, to review KPK's financial assurance, where both parties acknowledge that our staff desires to review financial assurance and KPK agrees to timely cooperate with staff in any review, to me has absolutely no teeth and no actual outcome. And maybe staff or KPK has a different opinion, and if they do, or the hearing officer, I would love to hear that. But I think I'm, along with Commissioner Njapa's comments, a little concerned about there being a deadline and or recommendations that come out of that maybe come to the commission for discussion. If staff sees that there are some concerns about the adequacy of the financial assurance amount or requirements. And I have some more questions. If anyone has comment of this, I still have additional questions.
I could speak to that, Chair Gonzalez.
AG Stafford, please.
Thank you. Commissioner McGowan, under current rule 702A, the director, when the director has reasonable cause to believe that the commission may become burdened with the costs of fulfilling an operator's statutory obligations, the director may petition the commission for an increase in any individual or blanket financial assurance. And we believe that that particular rule, which is already in effect right now, speaks to the concerns that I think you are voicing with respect to paragraph 7. Oh, I'm hearing an echo.
So
I think that echo might be coming from Mr. Jacobs's computer. I see that you're not on mute.
Apologies. And I guess I just wanted to wrap up and say, you know, understanding that we have that current rule in place, you know, we feel that this particular language in here allows us to, again, go back to the rules and use the rules in this way if we feel that we need to have a review or have the commission review KPK's financial assurance. We're not being precluded from doing so because we already sort of have that, you know, that regulatory option.
If I could also answer. I think he's recognizing me, but he's muted.
I am recognizing you, Mr. Robbins.
I too, Commissioner McGowan, had noted that language and that 50, is it 502, Ms. Stafford? I think it is.
702.
702. That 7, so the commission on its own can at any point in time utilize that 702 language as well. And so what I contemplated under this was the requirement or the desire, and if you guys want to turn it into a requirement with a deadline, that is fine with me as hearing officer, to undertake that review at the staff level, report back to commission, and staff may at that time recommend additional financial assurances, or the commission itself, upon receipt of said report, could use Rule 702 to require additional financial assurances. So that was where it's not in the language, but that was the sort of implied thought that I had going forward with that. Thank you.
Commissioner McGowan, more questions?
yes, thank you, Mr. Chair. So moving on to number 6, commission review of all transfers. So I think I was the commissioner mainly concerned with more assets being transferred to KPK before they kind of got their feet under them and could show that they could come into compliance with the assets that they currently own and oversee. And my understanding, and I could be wrong, so maybe AG Fugate could agree or disagree with me or provide some more insight around this. Our current rules and our authority does not allow us to say that an operator can or cannot sell their assets. But a legal binding agreement could contain such limitations, is my understanding, and that we could, as part of an NOAV or a compliance plan that both parties agree to, say, for some time period, no assets should be acquired while this operator comes into compliance. Would that be correct, or am I misunderstanding of what a legal agreement could contain?
I believe that was directed to AAG Fugate.
Yes, thank you, Mr. Chair. You are correct, Commissioner McGowan, that we are limited by law. We cannot restrict a private company's ability to purchase or sell assets. That is not something that's within the commission's authority. You're also correct that by agreement, a company could agree to be bound by that. However, in this instance, we were not able to reach agreement on that point. That's why the language in Section 7 on page 28 is limited, Section 6 is limited to just the commission's process as it relates to Form 9s. Without agreement, there is no authority to restrict a company's ability to purchase or sell assets.
Thank you. I appreciate the response. Sorry, I have a couple more questions.
Please go ahead.
For the training plan, which I'm super appreciative of because I think training was a huge, for me, kind of a core what kind of the core, or one of the core problems happening over at KPK. So I appreciate that there's going to be a training plan put together. As part of that training plan, I assume that staff with KPK will review and go through how we will know that a plan just wasn't written, but that it's actually being implemented by KPK. I think part of my frustration as a commissioner during this hearing was kind of KPK saying, or employees saying, yes, we had training, yes, I was trained, but an inability to document that training had occurred. And so I don't need it to be in this compliance plan, but an acknowledgement that I'm hoping that the training plan will deal with appropriate documentation of training activities for employees, so that we can do trust but verify and know that employees have been properly trained in all these aspects of our rules and how to comply.
I don't know who that question was directed to, so I'll look to hearing Officer Robbins.
Yeah, I would call upon AG Stafford, if that's okay, because this language was developed and largely by staff, I believe. So Ms. Stafford?
Thank you, Hearing Officer Robbins. Commissioner McGowan, with respect to your concerns about sort of the trust but verify approach to the spill release reporting and training plan, it's staff's understanding that yes, we would be sort of taking that approach as part of this. As contemplated in their plan, it will include documented training. Staff will approve when the training plan is appropriate. And, these are definitely two components of a good plan that we would expect to see and, further monitor under this particular larger plan.
Commissioner McGowan, additional follow-up or questions?
Yes. So for the flow line plan, I see that there was going to be there's recommendations for replacements, a recommendation for a schedule of upgrades or monitoring or replacements. And I'm wondering what comes out of the recommendation. Does that mean that there will be like a time schedule related to it? A recommendation to me is like, here's our recommendation, but I'm unsure then how that actually gets implemented or what the teeth is in the plan to have those pieces implemented. And so I was wondering if someone could explain to me what they thought would come out of that piece, or if I'm missing something.
Hearing Officer Robbins, who should we look to for that answer?
I defer somewhat to AG Stafford and or to her staff. They spent a lot of time developing the elements within the flow line plan. I think that, the plan itself is going to have items that need to be executed upon, and staff will be reviewing those items that need to be executed upon and ensure that they are indeed executed upon. It is a little bit, if you look at the language of the compliance plan, it is a little bit general. I agree in terms of the areas that need to be touched upon, but staff and myself would be reviewing that with our subject matter experts to ensure that those generalities of areas that need to be touched upon have specifics that are important based upon the evaluation. So it's a sequential sort of step to get to something that's specific that will have compliance requirements within it. That's my approach at trying to elaborate on what we were getting at with this document. There is a little bit of chicken or egg in all of these sorts of things, because the GRIP, the flow line plan, they all have to be developed with science and data in order to then develop what needs to happen to make things better out in the field. AG Stafford.
AG Stafford, anything additional?
Thank you, Hearing Officer Robbins and Chair Gonzalez. I would just note that at least the way that I am reviewing, subparagraph F here, we sort of, at least we intend as part of this plan to be working, closely with KPK to develop and implement, the requirements under this plan, and to work on particular schedules that may come out of, the evaluation that they do with respect to their obligations under this plan. So it's staff's perspective that the flow line integrity engineers will be integrally involved as we sort of move through this process. So we will have some, oversight. We will retain oversight of things that are occurring in the field with and with KPK's assets.
Thank you. I have three more.
Go for it.
Okay. What happens if we have new spills or new NOAVs, and how are those going to be addressed with the operator outside of this compliance plan?
AG Stafford, I see you are unmuted. Would you like to tackle that one?
Sure, I can take that one. The compliance plan in this respect is rear view mirror looking. We're looking at everything that we have on our plate as of right now. So going forward, we would, it's staff's understanding that nothing would change if there is an additional spill. Nothing would change in the sense that it might go through our regular enforcement process. We would, review accordingly whether the issuance of an NOAV is appropriate in that matter and proceed in that manner. But it wouldn't, the plan is not forward looking in that sense.
Thank you. And then I'm wondering if someone could explain to me why there's two balloon payments, but they're at the end of the 5 years instead of somewhere closer to the beginning. I'm just curious to know how that came to be.
Hearing Officer Robbins, you would like to walk us through that payment plan and kind of some of the decisions around that?
Yeah, no problem. And I could also probably allow Mr. Jacobs an opportunity to elaborate. This was a request by KPK associated with their request that there not be a payment in year one to allow it to use said funds to fund the corrective actions that are required. In that request, Mr. Jacobs noted that sort of approach with the balloon payments at the end is something that you will often find in consent decrees with other agencies such as the EPA. I noted that. I felt like there was a reason behind that response. And I think that I agreed, or I suggested that this is, seems appropriate. I think staff agreed as well. I'll stop there. And if Mr. Jacobs wants to add anything further to his client's needs on that front, please, I'll call upon the chair to recognize Mr. Jacobs.
Mr. Chair.
Mr. Jacobs.
Thank you. Yes, that was our request. The balloon, Commissioner McGowan, really just takes the first year payments and adds it to the 5th year payments. So they're double what the 2nd through 4th year payments are. Otherwise, it would be equal semi-annual payments spread over 5 years. And that was to allow us to put all of our available proceeds into getting started under these various plans and obligations of the compliance plan agreement, get our primary contractor on board, et cetera. Also, just incurring the expense of engaging the primary contractor primarily and doing all of the work that's required. The deadline's like a grip by December 31, which at one point sounded like a long time away, but it's coming up pretty quick. So that was the thinking behind the schedule.
Thank you, Mr. Jacobs. Commissioner McGowan. I saw your hand fly up, Hearings Officer Robbins.
Yeah, I had an opportunity to review the document, and I had another comment to Commissioner McGowan's. What happens if there are new spills? I would note that on page 27, Roman numeral 7, sub 5A, if a new spill or sets of spills occur and staff NOAVs them and they end up to commission in enforcement, this commission would have the opportunity to use that as a ability to terminate the plan, call for all outstanding amounts to come due, and otherwise all the other tools that you've remained in your toolbox would be applicable. So there's a fairly significant hammer on a go-forward plan that I failed to articulate in response to your question earlier, and I did want to get that on the record.
Thank you.
Hearings officer. I missed that part. Sorry, my last question, and this is going to put AAG Fugate on the spot, and he might not know the answer. I'm wondering if the commission has ever used penalty payments to put into sinking fund escrow accounts to set up financial assurance for the commission for an operator's assets.
Mr. Chair.
Mr. Fugate, please.
I don't believe the commission has used kind of an escrow account to kind of just have as a fund to cover costs. I know there's been discussions of how such a fund would work, but they don't have such a fund currently. And Chair Robbins may have a more detailed response.
Chair. Okay, I think you recognize me.
Mr. Robbins, please.
Thank you. I can answer that question going backwards when I wore a director's hat for this agency. And in particular, there was a large penalty that was imposed. And the issue, another issue there is that once money comes to commission, it goes into our environmental response fund, and we can't like set it aside for as a sinking fund. It like immediately goes elsewhere. And so it's not, if that's what you were trying to get at, I don't believe that is a tool that exists for us once the money's received by us. I think that, and I think as was answered earlier by AAG Fugate, we certainly could negotiate to have monies put into a third-party escrow, and then those monies set aside as sinking, et cetera. We talked about that, but did not receive agreement from all sides on that. And so that's where we are right now.
Commissioner McGowan.
Thank you, and thanks everyone for their responses.
Thank you for your thoughtful questions. Other commissioners with questions? Commissioner Messner.
Thank you, Mr. Chair. Just a couple of questions and a statement, I think. I mean, I do appreciate the work that has been put into this by Chairman Robbins, by staff, and by KPK. I do think that from this commissioner's seat that much of what has been developed in this agreement is something that is workable, meets my expectations to require compliance of COGCC rules by this operator and all operators in the state of Colorado. I think it creates an opportunity for this particular operator to put into action what they've stated in words, which is that they are willing to be compliant with the COGCC rules and operate in a responsible manner in the state of Colorado, which as of this point, at least in this commissioner's opinion, they have not shown. I do think that there's some teeth to this in some elements. I do think that there is also some carrots, and I think that's potentially what makes for a good agreement, but there is a significant amount of responsibility here, both on the operator as well as on the COGCC, which is the compromise. It is certainly my expectation as a commissioner that this agreement gets followed to the T, and will not hesitate should this agreement be agreed upon here today to utilize all the elements within the agreement to ensure compliance to this particular agreement. And so a couple of questions having said that. There is a section in this, and it's on page 9. It's the dedicated project account, which I think is an interesting idea. It does indicate that no later than 30 days from the effective date that there would be $150,000 deposit into the account by KPK And then the KPK will continue to maintain that $150,000 in that account on a monthly basis. Looking at the requirements and timelines associated with the agreement and potential timelines that are not specified in the agreement but are to be determined in a future date. My question is, and hopefully an acknowledgement by KPK, that the financial requirement in order to be able to meet the obligations of this agreement potentially are more significant than $150,000 a month in order to be able to meet the timing obligations. And so I guess I would be interested in an acknowledgement by KPK that that could be the case, and it is still understanding that it would be required to meet the timing obligations associated with the agreement, irregardless of that particular section that only requires $150,000 to be maintained in that account on a monthly basis.
Mr. Chairman,
Mr. Jacobs, please.
I believe that's directed to me. We negotiated that amount. Frankly, we wanted a lower amount, as you might expect. We conceded the higher $150,000 a month. We do not see it as a cap, if that's your concern, Commissioner Messner. That said, our resources are limited. We want to do as much as we can, and we need to implement and craft schedules in close collaboration with staff and the primary contractor to get the absolute maximum in terms of pace and quality of work to do all the work that's required out of the company while the company is able to continue to exist and operate. So that is not a cap, but that's not to say we have unlimited resources either. And I just want to make that clear.
That's fair. I appreciate that. That's the only question I have, Mr. Chair.
Thank you, Commissioner Messner. I will look to the other commissioners for any additional questions. Seeing none, I guess the next step might be to circle back on a suggestion from Commissioner Nanjapa. Do you wish to move forward with that suggestion? And I'm putting you on the spot here to potentially clarify any next steps you would like to see in this discussion.
Thank you, Mr. Chair. Yeah, I mean, I think, and I think Commissioner McGowan kind of raised some additional points, and I'll be honest, I'm a little fuzzy on if there was anything that we landed on specifically, but I do still feel fairly strongly that we need a little more specificity in this particular item, page 28, paragraph 7. This is related to the financial assurance and the review by staff. And, in the first part of it, I think, is related to the question that I asked AAG Stafford with respect to how much of the 1.5 million that we have for KPK in total pertains to the particular locations that we're talking about here, so that in a worst case scenario, what would we actually have that we could potentially claim. So I would like to see some specificity that, doesn't just indicate our desire for staff to do the review, but rather directs them to do it and by a certain time frame.
Thank you, Commissioner Nanjapa. I will look to councils for a response on that. And one suggestion I may have is if you have specific language, Commissioner Nanjapa, that may be helpful to throw out there. But we're also about to exit into an executive session as part of this afternoon hearing agenda, and that may give the respective councils for the parties an opportunity to consider your proposal. Do you have specific language you would like to offer, or are you throwing out kind of a theme of what you'd like to see, and potentially we can throw it back to the parties to see if they'd be willing to bring that forward in the next couple hours while we are adjourned to an executive session? I see AAG Stafford's hand up, so I will let her chime in before I let you chime in, Commissioner Nanjapa. AAG Stafford.
Thank you, Chair Gonzalez. I just wanted to make, I guess, a suggestion around this, and I apologize if it might not be my place, as I'm
I
not your
appreciate the
counsel.
suggestions.
But I'm not sure that maybe the language that Commissioner Nanjapa is thinking of needs to be included in the particular plan we've agreed to. It could potentially just be included in your order finding violation of this matter. But again, just wanted to make a suggestion there with respect to the fact that, you know, the parties have agreed to the plan as set forth in front of you, and I was trying to think creatively here.
I think that's an appropriate suggestion, and I thank you for that. I will look to our attorney in this matter, AAG Fugate, for his commentary on the matter. And I see hearing Officer Robbins has his hand up as well, so let's hear from you, Mr. Robbins, as well. I'll let you go first.
AAG Fugate, when you are providing your perspective on that as this being part of the order, it might be helpful for you to provide context to commissioners that the order has not been fully developed yet and will be finalized shortly and issued shortly. So I don't know that, I didn't realize that when I was hearings officer, and the commissioners may need some perspective around that. That could be helpful.
AAG Fugate.
Thank you, Mr. Chair. Yeah, a little more background and context on the fuller order, the more traditional findings of facts, conclusions of law part of the OFV hearing. We are working on that process. I'll look and see if there is a section in there that maybe we could address Commissioner Nanjapa's financial assurance issue. But before I do that, I want to make sure that I understand kind of the language that you're looking for, and correct if I'm wrong. It appears that it's more directed at staff to review financial assurance by a set deadline pursuant to the 702A process. So the ability to loop it back into existing rules, is that close to the mark that you're trying to hit here?
Commissioner Nanjapa.
Thank you, Mr. Chair. Yes, AAG Fugate, I think, you know, pursuant to Rule 702A, I know that we have this in our ability. I think, you know, I need to just think on it a little bit more, but I think the suggestion by AAG Stafford about putting it into the order could be appropriate. It piggybacks onto what's here in the agreement that has been agreed to with respect to language, but it creates a little bit more specificity for when and when that would happen. So that is my, you know, I think that's really the nut of my concern, is that it's not just a desire to see this happen. It is, you know, setting forth an actual action and a deadline for it to happen.
Commissioner Messner, I see your hand up.
Thank you, Mr. Chair. So I understand the suggestion that you're making, Commissioner Nanjapa. I think my question is, without having taken the time to fully analyze 702A right now, but my recollection is that we have the ability to do that anytime we want. At our next hearing, we can require or request staff to review financial assurances at a set date, irregardless of what's in the order, irregardless of whether or not it's in this particular agreement. Just know that from this commissioner's perspective, understanding the amount of time it's taken to get to signatures on this particular agreement, I'm going to be pretty critical of what we're going to do in order to adjust this agreement, because I am leery of opening this back up again to gain signatures at this point. And so this particular one, I think, could be addressed at a regular commission hearing anytime that we want.
Thank you for that comment, Commissioner Messner. I tend to agree in that regard. You know, I think that we have avenues to address this, and I share the concern that Commissioner Nanjapa has raised, and that I believe is along the same lines as a concern that Commissioner McGowan has had as well. May I suggest perhaps that we take it to to see if it fits in the order finding violation, and then if we can square it away in there, perhaps that's the appropriate venue. Otherwise, perhaps we can bring it up at our next scheduled hearing. I saw you had your hand up, Commissioner Nanjapa. I do not want to. I'd like to hear from you as well.
Thank you, Mr. Chair. No, I think what I was trying to suggest is that rather than trying to renegotiate the language in the actual agreement, to put it in the order, but I totally understand that we can do this at any time, but I do want it connected directly to this OFE. So I would like to see it in the order if that is language that we can change without having to go through an extended process where the language that's in the agreement still sort of dovetails with it and complements it, but we have the specificity in the order, if that makes sense.
I think that makes sense to me. AAG Fugate, does that make sense to you?
Yes, thank you, Mr. Chair. Yeah, I will review the draft order. There is likely a place in that order that we can put in this language to have this review conducted pursuant to the existing rules.
And to be clear, we will each have an opportunity to review that order before it becomes final, correct?
Correct. It's my understanding the board's typical practice is that I'll circulate the draft of that order for your review and edits. Again, it's the finding of fact, conclusions of law part of the order. So for Mr. Jakes and Mr. Mueller, we're not changing the terms of this negotiated agreement at all. This agreement will be just an attachment to that fuller order. This order is just the kind of the commission summary of facts, procedural history, and those kinds of conclusions.
And
Chair?
Yes, Mr. Jakes.
Just a question, point of order on the finalization of that order as described by AAG Fugate. Will KPK Counsel have an opportunity to review that before it is issued in final form? Just for purposes of any factual clarification, corrections, inadvertent errors.
Well, I'm not quite sure what the process is for that on a regular basis. AAG Fugate, what is that? What's our typical practice in that regard when it comes to issuing orders?
I believe, and Ms. Larson can correct me if I'm wrong, we do not share draft orders with parties to the action. Typically, we don't get involved in that level of detailed review from the parties.
What would be the remedy for a party that does not agree with the summary of the findings of fact or of any of the other summary from our deliberations that would appear in that order finding violation?
As far as if they just disagree with the statements in the order, or just
that's my question. I believe that's kind of what Mr. Jakes is attempting to prevent.
Sure.
But I just want to make sure that if we do not allow them an opportunity to, if we stick with our common practice, we issue the order unilaterally. I'm just curious, is there a process beyond that? Should a party disagree with a factual matter in that OFE or any other language of that order?
They could file a request to amend issued order with the commission. We could take their edits or revised language under consideration. Typically, I think we avoid having parties review the draft order because we don't want to engage in a kind of a rewrite of what we believe are factual determinations justified by the hearing.
Thank you, Mr. Fugate, and I agree with kind of that concern as well. I appreciate your question, Mr. Jakes. I think we'll follow our normal process. In this case, we will issue an order as a commission based on with the aid of our AAGs in drafting that. So that's how we will move forward in that. Mr. Fugate, not quite sure what our next step is here. Are we looking for a closure of this matter in a certain formal way? Please walk me through what we should be doing next.
Sure, and I guess I'd also look to the commissioners as well if they need any additional information from me. I know at the outset we discussed kind of the options that the commission could go through here, affirming the agreement, making potential modifications to the agreement, subject to agreement of the parties, or not affirming the agreement. One of the things that I indicated I could cover, and this might be the appropriate time, is in the event there is not a confirmation of this agreement, just outlining the provisions that are only here because of the agreement. Now, I don't want to go down that path if it's going to add confusion and complication. but I'll kind of at the commission's discretion as to what information they want from me at this point.
Do any commissioners have any additional questions for AAG Fugate that they'd like to hear at this time? Commissioner Nanjapa.
Thank you, Mr. Chair. And thank you, AAG Fugate. I think the one other question that I meant to ask earlier, or, seems like it's more related to whether this would be a modification to the agreement, or if it's something, now per the last discussion, whether we could put something into the order, was that, while I appreciate the intent behind, if there are disagreements or if there are, reviews that need to occur, that they go through staff and the hearings officer, Robbins in this case, that we, or I guess it does say the commission chair, at least for this commissioner, I think in particular the integrity plan was, I'm trying to remember what this, I'm trying to see what it was specifically called here, but related to the flow lines and the maps and et cetera, that was related to that. I think that was noted that it would go through, staff and the commission chair for approval. At least for this commissioner, I would really like to see that also. That was, to me, a very important part of this entire discussion and the agreement. And so I'm wondering if perhaps there could be, it could be modified to the staff and the commission chair make a recommendation to the commission, whether to approve or not, or, something to that effect. And then we could have the opportunity to ask questions and to approve it in a hearing.
AAG Fugate, would you like to respond to kind of that suggestion from Commissioner Nanjapa and what that might look procedurally?
Sure, and hearing officer Robin may provide some better context to kind of how you have utilized the commission chair as kind of various roles throughout this agreement. The two big ones are as kind of a mediator dispute resolution step before it gets to the full commission. As you see throughout this plan, there are various deadlines and other requirements that may be subject of dispute. We thought it would be more efficient to have a kind of a stage one dispute resolution before it goes to the full commission. I think Commissioner Nanjapa, your question is more geared towards some of the approvals of the plans or the contents of those plans, whether it's the flow line or the waste management plan. Again, the language here is that goes through the staff and chair as the kind of the initial reviewer and approval. I guess I'd leave it to hearing officer Robbins or the parties to whether there's value in having some of those plans being provided to the full commission, or what that process might look like.
Mr. Robbins.
Thank you. Yeah, the way, and I'll let Kath and Mr. Jacobs respond as well. The way that this was drafted, Commissioner Nanjapa, my part of the review was really probably more facilitate sort of a mediation if there were disputes between the subject matter experts at KPK and the subject matter experts at staff. I'm not going to bring a level or a lens of subject matter expertise that is going to be more valuable than the subject matter expertise of our flow line staff. And so that was what was contemplated, I believe, by the parties, because that document in particular is going to be fairly scientifically intense. And we have a whole staff that deals with flow lines, and they're the ones that really bring value to the review of what KPK is going to submit. Having said that, if KPK and staff find value in taking it to a full commission or don't find value, I think it's important to hear from them about that recommendation.
I'll look to Commissioner Nanjapa, clarification.
Thank you, Mr. Chair. Yeah, and I think I appreciate that, and I fully have the utmost confidence in our staff with respect to the technical details of the review. But it's just one of those things that I think and perhaps this kind of leads to another thought, is that as far as I understand here, and I'm sure that Chair Robbins, you would be giving us updates along the way, but other than the quarterly updates or the monthly reports that we would have to get out of COGCC, I think hearing, when the plan, in particular, I'm specifically concerned about on page 19, the flow line system integrity evaluation and plan, just because that was such a, that seems to be connected to several issues, including some of the unadjudicated NOAVs. And so I'm just wanting to have a look at that, or maybe have an opportunity to ask questions before it is approved, or possibly just participate in that process. And like I was suggesting, perhaps there could be a recommendation from staff and or the chair to approve. And I really don't mean to get nitpicky in this, but I think that was such a critical piece of all of this, at least for me, that it's the one component of this overall agreement that I would really like to see come before us. And again, that's just my opinion. So if others disagree, please let me know.
And Commissioner Nanjapa, let me clarify kind of what you're thinking, because I think I know what you're getting at, but I want to make sure that I understand it completely. Are you asking for an approval through the commission, or are you asking for a presentation to the commission?
Thank you, Mr. Chair. I think that's a good question, and a good question to clarify. I think maybe both. That's just my, as one commissioner's opinion. Definitely a presentation to the commission would be great. And as I was starting to note there, I think just sort of a notification or some sort of information that perhaps just Hearings Officer Robbins in this capacity could bring to us as an update. By the way, this was turned in on such and such date, in our weekly hearings and commissioner comments. I think that would be sufficient for most of it. It's just this particular flow line system integrity plan that I do have some more interest in hearing more of a presentation, and perhaps having a role as commissioners in the approval.
Thank you, Commissioner Nanjapa. Commissioner Messner.
Thank you, Mr. Chair. And Commissioner Nanjapa, I do appreciate your concern about this. I do think that this was one of the important pieces, in the agreement. I think and AG Fugate, please correct me if I'm wrong, but my understanding is that Rule 503 allows this commission to request anything associated with oil and gas operations in the state of Colorado to go to a hearing before the commission. And I would assume that would enable this commission to be able to have a hearing on this particular item, should we deem it to be an important piece and decision point in this particular situation. And so I may be wrong on that. And so certainly AAG Fugate, let me know if I've misinterpreted the rule.
AAG Fugate, I will look to you for that answer, and perhaps in the context of how it complements or works with the compliance action plan that's before us.
Sure. Thank you, Mr. Chair. Rule 503A does allow for the commission on its own motion to request that matters be set for hearing. I think maybe what Commissioner Nanjapa is looking for here is more of just being looped in on this specific plan. And I'm wondering, again, hesitant to modify the language here, but I think the important thing is getting notice of the submitted plans to the commission so that you can review those plans and be involved. The bigger question is notice and review enough, or do you want the commission to be making approval decisions on these plans? I think that might be a more significant, alteration of this particular plan.
Commissioner Nanjapa, I think you almost answered that last time, so I think perhaps we're looking for a more definite answer from you this go around.
Yeah, I mean, I think, again, just for me, it's this specific piece. I do understand we have other components of the rules that allow us to do all sorts of things, but I want to connect a specific action with this particular, either the agreement or the order. I don't know which is the most appropriate here, but I would like to see I would like to have a role. Again, this is just as me as one commissioner. I may get outvoted, but I would like to have a role in hearing what the staff thought, what Chair Robbins thought in his role as hearings officer in reviewing this particular flow line integrity evaluation plan, and then perhaps the commission having the opportunity to approve it. And specifically this one, I don't need to look at the other ones. I feel comfortable with the terms of what's in the GRIP and in the waste management plan. This one for me was very important, and that's where I am suggesting to insert the commission a little bit more strongly into this part. Again, I don't know if it's in the agreement language or in the order or where that would be, but I do want it connected to this whole enforcement action.
So AAG Fugate, it looks like we're, what Commissioner Nanjapa is suggesting is some sort of approval on the wellbore integrity plan, or the flow line integrity plan. She suggested that whether or not she gets outvoted, that triggers something in my mind as to whether or not our vote will be limited to kind of more micro aspects of this compliance action plan, or with or without any suggestion, if our vote is limited to an acceptance of the action plan as drafted before us, or a vote against accepting the action plan as directed before us, perhaps with instruction to contemplate the suggestions from commissioners today. I think that's the way I understand it to be, but I would also look to you to answer Commissioner Nanjapa's question, and then to tack on some info on what I've just asked as well.
Sure, Mr. I think I'll start with the potential modification of the subsection 9 on page 19 related to both the integrity evaluation plan review and approval, as well as the integrity plan review and approval. I think that changing this or modifying this from a staff and commission chair approval to a full commission hearing and approval is probably significant enough. I'd like to hear from the parties if that is an agreeable change in the process, or something that they want to further consider. Just because it will be a change in the agreed upon terms for this particular review and approval of this plan. As you know, in the plan, there are some tight deadlines, the April 1st and the July 1st deadline tied to both of those plans. So the more hearing process that we incorporate into this review, it does shrink the time for KPK to comply with those deadlines. So that's my response to the first one. And if you want to take that up with the parties now, we do that. If not, I can kind of move to my response to your, I guess the question posed of the commission today as to what action kind of the limitations as the actions today.
I think I'd like to hear that, and I'll just queue up KPK's attorneys to go first on responding to Commissioner Nanjapa's suggestion, followed by staff. But I would like to hear from you, Mr. Fugate, on kind of what the next step would be, kind of regardless of if we get consensus or not on Commissioner Nanjapa's suggestion.
Thanks, Mr. Chair. So I think the issue posed for the commission today is approval or denial of this plan as presented. Again, it's a precisely negotiated agreement, and that's the recommendation to the commission now is to approve this plan as submitted. I think that's the kind of the simple, narrow question of the commission is vote to approve or vote to not approve this plan as submitted.
Okay. Thank you, Mr. Fugate. I think that's helpful, and I think that helps us commissioners understand kind of what our role is going to be. I see your hand up, Commissioner Messner. I'll let you jump in here before I turn it over to the attorneys to respond to Commissioner Nanjapa's suggestion.
Thank you, Mr. Chair. So two things. I think understanding, Commissioner Nanjapa, what you're trying to accomplish, I have maybe a suggestion or a thought. So understanding AAG Fugate's answer there. I think there probably is a third option there, which is, should the parties agree at this particular hearing to something on the public record, that we could do a motion to approve with whatever modifications were agreed upon at this hearing. But I'm not suggesting that. My suggesting would be, should there be acknowledgement on the record here by staff that they would review these things with you and prior, as they were being developed, and allow you to ask questions and understand what it is, and should you find concern in those, that you would be able to utilize the 503 authority that the commission has to bring it to a hearing. Does that meet the need that you have without having to reopen the negotiated document that is in front of us today? So that's just a thought.
Sure. I'm going to assume that Commissioner Nanjapa understands those options before her. Commissioner Nanjapa, before I turn it over to the attorneys, do you have anything to add?
Thanks, Mr. Chair, and I appreciate that, Commissioner Messner, the suggestion there. I think there could be value in what you suggested with respect to having the staff kind of go over things as they're being developed. I'm not sure that the staff wants to do that, so that would be part of the question. The second part is, as you also noted, the potential to offer, a suggestion to modify the language that could potentially be accepted with a modification that if the parties were in agreement. I don't think that what I'm asking, at least in my mind, is again, fully having confidence in the staff and their ability to technically review and recommend an approval, just the opportunity to ask a few questions and understand what got approved before it is approved and just, a done deal, I guess, is where I'm coming from. Again, not to cast doubt on staff or anybody else, but rather just because this was such an important part, just being able to have a little bit more of a role in that particular plan. So I guess I would look to AAG Stafford with respect to, both of these thoughts, whether there would be sort of opportunities to discuss with commissioners as the plan is being reviewed versus having this opportunity to present and have the commission have a role in the vote. And I do not mean to drag this out. This is an important piece to me, so I don't want to just drop it.
Yeah, I appreciate the importance of this, Commissioner Nanjapa, and I think that we'll hear from the attorneys at the end of the day. We'll be able to vote based on what we hear and based on the concerns we have in that compliance plan or the faith we have in that compliance plan as well. So kind of turning it over, I would like to hear from the attorneys on this, specifically in response to Commissioner Nanjapa's suggestion. I'd like to hear from KPK's attorneys first. So Mr. Mueller, Mr. Jacobs, if either of you would like to respond, you would have the floor.
Thank you, Mr. Chair. Happy to respond. We're very reluctant to open the agreement. The flow line evaluation and integrity portion of the agreement was one of our biggest concerns and the subject of a lot of negotiation and back and forth and assistance from Hearing Officer Robbins. The language in there was agreed to ultimately after a lot of effort. Somewhat in the nature of Ms. Stafford's suggestion earlier, it occurs to me that without changing the signed and agreed to compliance plan agreement, the parties could appear before the commission to report on the evaluation plan, but not with an approval required, simply informational, and that would give you an opportunity to express concerns that we could then give consideration in our discussions and work with Hearing Officer Robbins if necessary. So I think that's the best we could offer in a manner that doesn't undo the agreement or require its revision. And still address your concern. And I do feel I need to just say that making minor changes to the order outside of the agreement to affect the timing of something like the financial assurance review is one thing, but doing things in the order that purport to amend the agreement substantively would be very objectionable to KPK. And I think that's consistent with what Mr. Fugate advised you, but thank you, Mr. Chair and Madam Commissioner.
Thank you, Mr. Jacobs, for that response. I see Hearings Manager Larson has appeared, so I'm going to let her chime in with additional commentary. I'll turn it back over to you, Commissioner Nanjapa, after that, and then we will continue. And I will also give AAG Stafford an opportunity to respond if she has additional response, but I'd like to hear from Hearings Manager Larson first.
Thank you, Mr. Chair. Just one matter to note. I think as the parties have explained and Hearing Officer Robbins has explained, the flow line integrity plan was a very closely negotiated element of this plan, and staff was successful in reaching agreement with KPK to ensure that KPK goes above and beyond what our current rules provide. So the plan and the efforts that are envisioned under that flow line integrity plan go beyond where our rules currently are. And the only thing I might note is if the commission seeks to review and approve that plan beyond what is contemplated in the compliance plan, potentially, and I would defer to AAG Fugate, but potentially there may be some concerns there if the commission is seeking to go even further than what has been approved and contemplated under this compliance plan. So I think that's just something to be aware of.
Commissioner Nanjapa.
Thank you, Mr. Chair. And not to jump in before AAG Stafford responds, but I did want to just note, I really did appreciate that suggestion from you, Mr. Jacobs. I think that would accomplish it for me. I think if there was a presentation along the way prior to approval where we could ask some questions or perhaps voice some concerns, maybe that's all. I think that would do it. So that would satisfy me. I also fully appreciate what you said with respect to, I'm not trying to make end arounds to the agreement and create new terms in order, but to the last point with respect to financial assurance, it was more just kind of putting a firmer date on that action that's already specified in the agreement. So with that, I will withdraw any suggestion to modify the agreement and request that we simply have an update as that plan is being reviewed.
Sure.
If that would be amenable to my other fellow commissioners.
Thank you for that suggestion, Commissioner Nanjapa. And before I hear from the rest of the commissioners, I'd like AAG Stafford to respond to your initial question and if she has any additional commentary. And then I would also ask AAG Fugate following that if he could help us figure out how that would be formalized kind of in these proceedings. So AAG Stafford, do you have anything to add?
Thank you, Chair Gonzalez. I just would like just to put on the record the staff's perspective on this. That being, I think we're generally in agreement with Mr. Jacobs's proposal that a report or discussion, sort of as we're working through the plan, to offer thoughts that each party can consider in finalizing the plan would probably be the most appropriate way to go with this, and we could get on board with that.
I would be supportive of the suggestion from Mr. Jacobs. It seems it would satisfy Commissioner Nanjapa's requests. I see Commissioner McGowan nodding. Commissioner Messner, would you also be supportive of that? Do you have any additional commentary? Please.
I'm supportive of that if it doesn't require any modification of the agreement. I think it's a finding at this point and a part of the record that could go into an order, though.
Yep. Thank you for that, Commissioner Messner. And now I'll turn it over to AAG Fugate to let us know how we can formalize kind of that suggestion and I guess commitment from the parties in that regard.
Thank you, Mr. Chair. Sorry, I'm getting some echo there. Mr. Jacobs, that might be from your end. I think with this discussion and kind of note that we're not changing or modifying this agreement, I think we can make a point in the order itself that presentations will be held by Commission on these plans.
I think that would satisfy the concerns, and I appreciate the discussion on that and the cooperation from everyone. Yes, Mr. Jacobs.
Point of clarification, I believe Commissioner Nanjapa was specific to the flow line evaluation plan. That was my suggestion for a presentation on the flow line evaluation plan. That is all I suggested.
I believe that was I believe her suggestion was limited to that as well. Commissioner Nanjapa, please clarify if that is incorrect.
Thank you, Mr. Chair. Yes, I was being specific to that, although I would not object to presentations on the other plans.
Sure. We'll limit it to kind of the specific plan that you had originally made your suggestion around, that Mr. Jacobs and Ms. Stafford have agreed to. I think we're all on board with that. So I see 9 of heads. So it looks like that will end up in our final order that Mr. Fugate will help us draft. I think that's the end of that matter.
One last point of clarification, if I may, Mr. Chairman. I do apologize. There's some confusion even among our team. We're talking about the flow line system integrity evaluation under section 4.9A of the compliance agreement, are we not?
So
I just
I'm
want
going
to be
to,
absolutely clear.
I think it's important that we clarify that to the appropriate part of the action plan, of the compliance plan. So 9A being the integrity evaluation plan, and
Right.
Romanets associated with that 1 through 5. Commissioner Nanjapa, I believe that's what we're all talking about, but let's make sure that we're all on board with that.
Yes, thank you. I think that is the correct section. Let's see. Yes, 9A is the one that I am referencing. Thank you.
Ms. Stafford, are we all clear on that?
I actually would like to clarify that. So 9A, we're discussing the evaluation. 9D discusses the integrity plan. So, yeah, I think
And
further clarification is needed.
it's my understanding that, if I may, Mr. Chairman,
Please, Mr. Jacobs.
that Commissioner Nanjapa was concerned about a presentation on the evaluation in 9A, and that's why I just asked the question I did, which I believe she agreed with. 9A.
Well, I believe she agreed with it as well, but we are also, we've got a big document before us that we've had, limited time to work with, and we're trying to make sure that we get to the right spot. And so it was my understanding, her original suggestion, that she wanted to hear about the plan that would be implemented as part of the integrity evaluation. Now, I'm not quite sure, and I'm not going to speak for Commissioner Nanjapa in that regard. It was also, that was my understanding from your suggestion, Mr. Jacobs, that it would be a presentation on the proposed plan, not just on the evaluation. So that being said, that's what I heard, at least along the way. Commissioner Nanjapa, this is your suggestion. I will allow you to continue to help us clarify this, and then we will make sure that we're all on the same page.
Thank you, Mr. Chair, and thank you all for your patience with this. I am interested in, and would just first agree with your note that we've had to digest this in a relatively short period of time, only because we were pretty booked up most of the last few days. But I am most interested in the plan, but I think the suggestion was a presentation, as it's being developed, and we can ask questions and offer concerns. So if, I don't know if that would be as part of the evaluation or after the evaluation is complete, but before the plan is completed, ultimately I'm just I guess the point of clarification is before the plan is approved, I would like to see the presentation that discusses what was, what was evaluated, what went into it. And as I understand it, that would be, 9A Romanets 1 through 5 as part of the evaluation. but then, understanding what plan is being developed as part of that. I hope that makes sense.
Well, I think we may look back to you for some more specification here, because we're dealing with something that's, part of these negotiated terms. And I think that it's important that we dial in what we're talking about here. Perhaps a suggestion that I may offer, to bridge this, is that prior to any plan being approved before KPK and before or between KPK and staff, that plan comes before us, at least to discuss the progress associated with the development of that plan and the of reporting, I guess, on the evaluation, because the evaluation doesn't really require any action out of KPK. It is an evaluation that presents information that we would like to hear from as well. I see your hand up, Hearing Officer Robbins. Please.
Thank you. I kind of like to suggest something on this point. So the evaluation that is done at 9A is done by an independent third party. And there's no need, from my perspective, for commissioners to be involved in that. That's a third party subject matter expert that then will influence the creation of the integrity plan at 9D. And so I think what I'm hearing from Commissioner Nanjapa is, before the integrity plan that is approved by staff and myself, with a great deal of reliance, if not 100% reliance, on the subject matter experts that is our flow line integrity staff, Commissioner Nanjapa would like to hear about the evaluation and provide context on what the integrity plan ought to look like.
I think that's my understanding as well. I think you've articulated probably better than we have, and perhaps between all of that, AAG Fugate will understand what we're talking about. But I think we're getting it dialed in pretty well. Now, Mr. Jacobs, because we are being precise here in what our suggestion is, it is to hear about the integrity plan as contemplated in 9D prior to that plan being approved by both parties. Is that a suggestion that you would be in agreement with?
It's slightly different than my suggestion as originally framed, but based on this back and forth, I think we can agree to that.
Okay, thank you, Mr. Jacobs.
Without the need to modify the agreement.
Thank you, Mr. Jacobs. Ms. Stafford?
Thank you, Chair Gonzalez. That is okay with us as well.
Okay. I think that gets us in the right spot. Mr. Fugate, do you have anything to add, or are we in a good spot to continue our discussion?
I have enough. Thank you very much, Mr. Chair.
Okay. I think at this point, and someone interrupt me if I'm wrong, but I think at this point we have we've asked all of our questions, and perhaps we are now looking for a motion to accept the compliance action plan as negotiated between KPK and staff on docket number 20110261. And for clarification, that's the compliance plan agreement is the formal title.
So moved.
We have a motion. Do we have a second?
Second.
Motion and a second. Do we have any discussion? Seeing none, all those in favor say aye.
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 Motion carries. And I believe that is the conclusion of the matters associated with this docket. Mr. Fugate, please correct me if I'm wrong. If it is, then I think that I'd look to you for a direction on how to properly close this out.
Thank you, Mr. Chair. With that vote, I believe this docket number, this matter is closed. As we've discussed, I will finalize the draft order, circulate that with the commission. Under the rules, we do have 30 days to issue that written order. My goal is to get it to the commission early next week and have this matter resolved with the final written order out to all of the parties.
Thank you, Mr. Fugate. I think we'd like to move this along sooner rather than later, so appreciate the urgency there. With that, I believe that that staff and KPK counsel can be dismissed. Again, I'd like to say thank you to y'all as well as to Hearing Officer Robbins for all the effort that went into this compliance plan agreement, and I look forward to its successful execution and to hearing more about it as it kind of formulates and gets into practice.
Thank you, Mr. Chair.
Thank you, Mr. Chair.
I believe the next item on our agenda is a planned executive session to hear legal advice from our attorney on a motion pending before us. And I will look to AAG Mercer to help me with the script to get us to the right spot and into executive session.
Thank you, Chair Gonzalez. Pursuant to the open meetings law, the commission is entitled to enter into executive session at this regular meeting for the purpose of discussing pending or imminent court action with commission counsel and to receive legal advice pursuant to Colorado Revised Statutes section 24-6402-3A2. The topic of the executive session was identified on the agenda for executive session. That topic is to receive legal advice and analysis as authorized by 24-6402-3A2 CRS regarding the motion for a temporary moratorium of consideration of pending and new applications for transfer of ownership until new financial assurance rules are effective. And that motion was filed in docket number 2106000097. The commission will not deliberate, make any decisions, or vote in this executive session. And with that, I would look to you, Mr. Chair, to invite a motion to enter into executive session for the matters and purposes I just named.
I so hereby encourage that motion.
So move. I don't ever get to move. I move.
Second.
I have to move.
A motion and a second. All those in favor?
Aye.
Aye.
All right, then we will exit this meeting and enter our executive session. We will reconvene here upon conclusion of that executive session. I believe we can leave an open-ended time anytime between now and 5 p.m. is what we anticipate. So that is what we will plan on. And we will see everyone back here when we are done.
Great. I think we're all back. This is the Colorado Oil and Gas Conservation Commission. We have concluded our executive session. And I would look to AAG Mercer for the appropriate remarks so that we can be finished.
Thank you, Chair Robbins. We are returning from executive session. During the executive session, the commission received legal advice on the motion for a temporary moratorium of consideration of pending and new applications for transfer of ownership until new financial assurance rules are in effect. That was filed in docket number 2106000097. During the executive session, no decisions were made and no votes were taken. Chairman Robbins, I invite you to encourage a motion to exit executive session.
So encouraged.
So moved.
Second.
We have a motion and a second to exit executive session. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. I believe that concludes the items that were agendized for us this afternoon. Does any commissioner have anything further before we adjourn? All right, seeing none, I would look for a motion to adjourn.
So moved.
Second.
We have a motion and a second to adjourn. All those in favor signify by saying aye.
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 Any opposed? We are adjourned. Everybody have a great, wonderful weekend. Bye.